Sometimes one of the more challenging assets to do asset protection for are retirement accounts. There is a general understanding and sometimes a misconception that retirement assets are inherently asset protected from the claims of the retirees or debtors, third-party creditors. Now, that is the case when it comes to ERISA qualified plans such as 401ks, 403bs, defined pensions, things that are what are called ERISA qualified, ERISA being the Employee Retirement Income Security Act of 1974. But that doesn't apply to all retirement plans as a blanket statement. For example, in some states like here in California, we do have some limitations on things that are IRAs that are not 401ks. It could be IRAs, it could be SEPs, simples, or their Roth equivalent. And so when people think about, hey, well, my retirement plan is protected, that may be the case if you have an ERISA qualified plan, such as a 401k or a 403b, but that may not be the case with state-based plans such as IRAs, SEPs, or simples. And sometimes they also get confused because they say, hey, well, my IRA is protected up to $1 million plus in a bankruptcy setting. Yes, that is the case, but that's not so much the case with state-based codes and civil procedures and how do you protect them from the claims of third-party creditors. So here in California, we have some challenges because in California, IRAs, again, SEPs or simples or Roth equivalents, are only protected to the extent necessary in the court's discretion to what is deemed reasonable for the retirees and the retiree spouses' reasonable retirement needs, considering income from other sources. And what does that mean? I don't know what it means. The reasonable standard is a big gray area. So when it comes to retirement assets, we always would take a look and see, well, do our clients have IRAs that need to be protected? And so one of the things that we turn to is not so much relying on the California Code of Civil Procedure. We then turn to other more well-known asset protection tools such as LLCs. So what I'm going to do here is I'm going to share with you my screen, and I'm going to show you one of the tools that we use. And one of the tools that we use is a IRA-owned LLC. And so here what we're doing is we're relying on not so much the integrity of the IRA itself, but now we're going to look at a LLC structure that gives us the charging order protections that you've heard me talk about in previous videos. So here we take an existing retirement plan, such as an IRA asset, which is typically under a traditional custodian, whether it's Wells Fargo, Fidelity, whoever your traditional IRA is with, and we have to put it over to the custodian of a self-directed IRA. So we need to get this over into a self-directed environment. Now we have a very good working relationship with a company called UDirect. It doesn't have to be them, but we have a good relationship with UDirect IRA Services LLC, and they help to facilitate the transfer from your, let's say your Wells Fargo IRA over to a self-directed IRA environment. Now that you're in a self-directed IRA environment, a couple of things happen. Our firm helps you to put together a very specialized IRA-owned LLC. Now, this is not just any old LLC you pull off the shelf. It has to be very specifically tailored, specifically drafted IRA that will not result in a disqualification or prohibited transaction when it comes to dealing with the retirement assets. So we established this LLC for you. Your money is sitting with the self-directed IRA custodian, and then an exchange via a direction order takes place. There is a purchase of 100% membership interest in the LLC in exchange for the IRA assets. That's why it's a self-directed IRA. You can now buy LLC membership interest that maybe Wells Fargo or some other traditional custodian won't allow you to do. Now, this LLC, the nice thing about it is that you are the manager of the underlying LLC. And if you hear things like buy gold in your IRA or buy real estate in your IRA, this is how it's happening. It's first you're transferring it into a self-directed environment, and then you should have those funds allocated to a IRA-owned LLC. So now that you get what's called checkbook control, you now have checkbook control over your IRA assets. This way you can now invest in real estate, you can invest in coconut blossom trees and farms, you can purchase real estate and vacant land in foreign countries, you can buy gold bullion, whatever you wish to do. This is where you hear about these alternative investments where you now get to start investing in what you know best. There are some very specific rules on what you can and cannot do within the IRA environment. And I always like to say, with great power, that is the power over your own retirement assets, also comes great responsibility. And that responsibility really means that you need to take the time and to learn about the do's and the don'ts when it comes to managing and having checkbook access over your otherwise qualified retirement assets. But now, not only do you have the flexibility of investing in what you know best, or put it right back into your brokerage account or mutual fund account. You can do that as well. But now, when the creditors come attacking you, you now have asset protection, because now your IRAs are within this LLC environment. And as a result, you now have asset protection over your IRA assets, which the California Code of Civil Procedure does not give you. So this is the tool that we use to protect IRA assets when you have those kinds of personal liability exposures. So if this was helpful, or you have some questions about the use of IRA-owned LLCs, or maybe you already have a self-directed IRA and you want some assistance, or you want to put those into an IRA-owned LLC to enhance your investments in an asset-protected environment, give me a call. My name is Brad Barth. I'm a partner here at Barth Calderon, where we plan today for all of your tomorrows. Thanks for your attention. Bye-bye.